Hello and welcome to our latest webinar, the 12th in our series. I'm Jeremy Glover, a partner here at Fenwick. Now, we featured a wide-ranging number of themes over the past weeks in our webinars, including adjudication, construction in the time of COVID-19, the virtual technology and construction court, fire safety in tall buildings, building information modelling, even bonds, but not arbitration or dispute boards. So I'm pleased to say that we're rectifying that omission today. And I'm very pleased to be joined by two of Fenwick Elliott's senior associates, Mahmud and Robbie McCrea. Now, I joined Fenwick Elliott over 20 years ago, and we've always had strong links with New Zealand. And Robbie is one in a long line of excellent lawyers who've come in from that country. On the other hand, Sana's more homegrown, having started here as a paralegal and trainee. She now flourishes as part of our international team. Together, they have a wealth of experience on the topics they're discussing today. So without further ado, Robbie, over to you.
Thank you, Jeremy. Now, no doubt everybody tuning in today will have some experience with arbitration and dispute boards. At least in international contracting, both of these mechanisms are now included by default in most construction contracts. The plan today is to take you through what will be a whistle-stop tour of the key features and some recent trends in both of these mechanisms. This will cover the basics, the legal basis of both, the procedure and some procedural issues, enforcement and enforceability, and of course, lessons from COVID-19. Broadly, Sana is going to be in charge of arbitration, and I will deal with dispute boards. So let's start at the very beginning, and I'll hand you over to Sana with the basics.
Hello, everyone. In very basic terms, DBs and arbitrations are both private consensual dispute resolution mechanisms agreed by the parties. When entering into any construction contract, the default position will usually be that disputes can be referred to the courts of the governing jurisdiction of the contract. This can be amended in two ways. Firstly, the parties may agree to use arbitration instead of the courts as the mechanism to finally determine the merits of their dispute under the contract. Secondly, the parties may agree to introduce a preliminary dispute procedure, such as a DB, which must be completed before a dispute can be referred to formal proceedings such as arbitration or court. Several jurisdictions provide for a preliminary adjudication mechanism by law in the form of statutory adjudication schemes, such as the English Housing Grants Act and in New Zealand, the Construction Contracts Act. Similar statutes are applicable in Australia and Singapore as well. Where no such scheme exists, parties can choose to insert a DB mechanism into their contract. Once included in the construction contract, these mechanisms will be mandatory for any disputes going forward. Robbie?
Dispute boards and arbitral tribunals share a number of common features. They both consist of a person or panel of 3 or more people that is independent, impartial, and suitably qualified and experienced, is selected and appointed by the parties to issue recommendations in the case of DBs only, and/or decisions in relation to disputes arising out of contracts. Now, DBs and arbitration are not a like-for-like comparison. They fulfill different roles, and both mechanisms are commonly included as part of the same dispute resolution procedure. However, as the two leading ADR mechanisms in construction contracts globally, there are interesting comparisons to be made as to how they are both implemented practically and how they are being used and developing today. Sana?
So, in a nutshell, arbitration is effectively private litigation. It is a relatively rigid procedure designed to finally decide any dispute that is referred. The key benefits of arbitration include confidentiality. Unlike court cases where judgments are publicly available, arbitration awards are kept private. Hearings are also conducted in private. Excerpts of anonymized awards, however, can be published by arbitral institutions such as the ICC, but they have to have the consent of the parties to do that. Secondly, flexibility. The parties have the benefit of being able to appoint a tribunal of their choice and can exercise some degree of control in setting the procedure used to resolve their dispute. Cost. Now, this is a bit of a tricky one because theoretically arbitration was supposed to reduce the time and cost involved in resolving commercial disputes as compared with court. However, in reality, this is not always the case. Large-scale complex disputes are invariably expensive. In order to improve the efficiency of arbitration as a commercial dispute resolution mechanism for smaller claims, in 2017, the ICC introduced an expedited procedure as part of their rules, which is designed to apply to cases with a value of under $2 million US. This expedited procedure aims to provide the parties with an award 6 months from the date of the first CMC. A normal arbitration process would, in most cases, exceed the time and cost of a dispute board process. Another factor is limitation. As with issuing a claim in court, issuing a notice of arbitration stops limitation running. The same cannot be said for the DB process. And lastly, enforceability. Awards are enforceable almost everywhere thanks to the international regime provided by the New York Convention. We will touch on this a bit later. Now, for downsides, unlike dispute boards, arbitration is not responsive. It is a final procedure which deals with the claims after the fact. An exception to this may be the use of emergency arbitrator procedures now included in most rules, but those procedures are very limited in scope. Another issue is the aggregation of claims. The nature of the process often leads to the aggregation of claims to be dealt with together at the end of a project. This approach can often cause cash flow issues for contractors, which is something the introduction of DBs is designed to mitigate. And finally, cost again. As mentioned previously, large-scale complex international arbitrations where you have numerous parties, large legal teams, several witnesses and experts are almost invariably expensive. The parties will also have to pay the tribunal's fees, expenses, as well as administrative costs where the arbitration is administered by an institution. Robbie?
Okay, so in a nutshell, dispute boards are a preliminary procedure. They're designed to quickly resolve issues and claims and avoid them turning into disputes that escalate. Importantly, they do not supplant formal and final proceedings such as arbitration, except in very limited circumstances. Dispute boards should ideally be set up at the start of a project and remain in place for its duration. They're intended to become part of the project team and provide a continuing forum for discussion of issues that might become contentious. As to the key benefits, like arbitration, dispute boards are private and parties can choose the identity and number of dispute board members. Unlike arbitration, dispute boards are highly customizable. They also have a dispute avoidance role, which is arguably the key role of dispute boards, along with maintaining cash flow for the contractor. A proactively involved DB should encourage issues to be resolved amicably and discourage the parties from adopting extreme positions. They also help with the resolution of disputes in real time. Disputes should be referred to the DB as they arise, meaning that the DB is able to see the project work and hear from those involved at the time, and the DB should also have the advantage of starting from a position of knowledge about the project already. Unlike arbitration, DBs help to avoid the aggregation of claims, in theory at least. And finally, where decisions are required, DBs involve significantly reduced procedural steps, timeframes, and costs. As to the negatives, upfront project cost is generally the main argument against the early appointment of a DB. DB members are remunerated throughout the project, usually through a monthly retainer, plus a daily fee for time spent carrying out its functions. These costs will usually be dwarfed by the cost of arbitration, which might be avoided by having a standing DB, although of course parties rarely anticipate that arbitration will be necessary when entering into a contract. It is nonetheless important to select the DB that is appropriate for the project, and I'll go through the various options when we get to procedures. Other negatives include that DBs are not a recognized legal concept in and of themselves, and this means that there can be enforceability issues, which I'll discuss later, difficulty enforcing procedures if one party does not cooperate, and commencing a DB procedure, unlike arbitration, does not stop limitation running. So this takes us to the legal basis, and I'll hand to Sana.
When looking at the legal basis of arbitration, I think it's useful to consider the two following points. Firstly, separability. Arbitration agreements are separate agreements to the contract, and the applicable law of the arbitration agreement is often different to the governing law of the contract. The doctrine of separability allows parties to enforce the arbitration agreement even where the underlying contract is either terminated or otherwise deemed invalid. Secondly, international enforceability. Arbitral awards are defined by the Convention on the Recognition and Enforcement of Foreign Arbitral Awards, also known as the 1958 New York Convention, which currently has 164 signatory states. So both foreign and domestic arbitral awards are enforceable by law in most countries. An English case that set out the test to determine the governing law of the arbitration agreement was SulAmerica in 2012. The Court of Appeal in SulAmerica sought to clarify uncertainty around the law that should apply to the arbitration agreement if none is expressly stated. Previous case law on the issue had been inconsistent. In some cases, it was decided that the law of the seat would apply, whilst other cases sided with the law of the contract. The Court of Appeal in SulAmerica formulated a three-stage test to determine the law of an arbitration agreement. The first limb of this test was, is there an express choice of law governing the arbitration agreement in the contract? If the answer to that is yes, then that's where we stop. That law will apply to the law of the arbitration agreement. However, if there isn't an express choice, can a choice be implied? And thirdly, in the absence of a choice, which law does the arbitration agreement have the closest and most real connection? In this case, the governing law of the contract was Brazilian law, and the seat of the arbitration was London. There was no express choice of law governing the arbitration agreement. The Court of Appeal stated that the starting point, absent any indication to the contrary, was that the parties intended their relationship to be governed by the same system of law as that governing the substantive contract. However, two factors pointed away from that presumption. Firstly, the choice of London as the seat, and secondly, the fact that the effect of Brazilian law would mean that the arbitration agreement was only enforceable with both parties' consent. The latter factor in particular swayed the court to decide that English law was the applicable law of the arbitration agreement. However, earlier this year on 29th April, the Court of Appeal in Enke and Chubb issued a decision that once again sought to impose some order and clarity on this area of the law. The Court of Appeal there held that the starting point was to apply this three-stage test articulated in SulAmerica. However, it differed on the presumption that should apply. The court in Enke stated that where there is no express choice of arbitration law, the general rule is that the party's implied choice is that the law of the arbitration agreement will be the same as the law of the seat at the arbitration, unless there are particular features of the case demonstrating powerful reasons to the contrary. The case involved a subcontract relating to the construction of a power plant in Russia, with an arbitration agreement seated in London. When a fire damaged the power plant, the insurers Chubb Russia commenced court proceedings against Enke in Moscow. Enke then commenced proceedings in London seeking to enforce the arbitration agreement and to confirm the applicable law. In applying the principles above, the court held that the proper law of the arbitration agreement was English law. There was no express choice of arbitration agreement law and no countervailing, let alone compelling countervailing factors to rebut that general presumption. The current position under English law, in summary, is that the seat of the arbitration will be the applicable law of the dispute resolution provision unless the parties have expressly chosen otherwise, or there are compelling reasons otherwise. It should further be noted that the decision in Enke and Chubb is currently the subject of appeal. The Supreme Court hearing took place earlier this week and the judgment is awaited. The test in SulAmerica has also been applied by the courts in Singapore. Interestingly, in Singapore, in First Link Investments, the High Court welcomed the three-stage test applied in SulAmerica. However, it disagreed that the starting point for the second stage of the test should be a presumption that the main contract law would apply to the arbitration agreement. This presumption, however, was reversed in 2016 in BCY v BCZ. The High Court there confirmed that the correct position under Singapore law is to apply the three-stage test in SulAmerica, in respect of which it emphasized that the governing law of the main contract is a strong indicator of the governing law of the arbitration agreement, unless there are indications to the contrary. The court therefore held that the applicable law of the arbitration agreement was that of the governing law of the contract and not of the arbitration seat. Robbie?
Okay, the legal basis of dispute boards is a much shorter story. DBs are established purely by contract, and this means that dispute board powers and procedures can be whatever the parties decide them to be. The powers given to the dispute board will be grounded in the contractual force provided under the applicable law, i.e. they will be enforceable as a contractual obligation. Naturally, this also means that dispute boards are not separate to the construction contract that they've been incorporated into, unlike arbitration agreements, which are separable. And fourthly, it also means that the applicable law of the dispute board procedure will be the governing law of the contract. And this is explicitly stated, for instance, by FIDIC and the Chartered Institute of Arbitrators, CIARB, as shown on the slide. Now, it's worth just briefly noting that the position on applicable law gets slightly trickier when it comes to enforcement, and the applicable law of the contract and arbitration agreements are different. And I'll look at that shortly. But first, on to procedure. And Sana.
There are two approaches here, institutional arbitrations versus ad hoc arbitrations. Arbitration clauses in standard form contracts will often have a set of procedural rules from a dispute resolution institution incorporated by reference, which can be amended as necessary by the parties. For example, FIDIC incorporates the ICC rules in its arbitration clauses. Other institutions that have published rules include the Singapore International Arbitration Centre, DIAC, and the LCIA, amongst others. The key consideration when choosing an arbitral institution is fees, which can vary significantly. Where institutional rules are incorporated, the chosen institution will supervise the arbitration. This provides a neutral framework in which the arbitration can be administered smoothly. Where institutional rules are not specified by the arbitration clause, theoretically, the parties are free to agree the procedure and appoint the arbitrators as they see fit. However, in reality, the scope to design or amend the procedure is limited because it must comply with national arbitration laws and the New York Convention if an award is to be enforceable. Applying institutional rules minimizes this risk. Robbie?
Like arbitration, dispute boards are usually included in construction contracts by referring to a set of institutional rules that can effectively be plugged into the contract. However, whereas in arbitration, there's little procedural difference between the rules offered by the various institutions. With DBs, there are wide variations and several established types of dispute boards to choose from, the most common of which are dispute review boards and dispute adjudication boards. Dispute review boards originated in the USA and are still mostly found there. They entail a person or panel of experts retained throughout the project and charged with holding regular meetings and who can offer informal advice when a dispute arises or issue recommendations, which are basically non-binding decisions. Now, although recommendations may seem like a light touch, DRBs are actually very effective. For instance, they're used by default in contracts by the California Department for Transportation, who has reported that in addition to disputes avoided altogether, nearly 60% of DRB recommendations are accepted by the parties. Dispute adjudication boards originated in the 1990s in the FIDIC contracts in collaboration with the World Bank. They involve either a standing board in place for the duration of the contract, i.e. e.g. FIDIC's 1999 Red Book, an ad hoc board appointed only when a dispute arises, such as in FIDIC's 1999 Silver Book. And in both cases, they're empowered to issue decisions intended to be immediately binding on the parties. Combined dispute boards are offered under the ICC rules, which allow parties to choose to have a DRB, a DAB, or ICC's hybrid version, the CDB. Combined dispute boards issue non-binding recommendations by default. However, they can also issue binding decisions in some circumstances. Finally, dispute adjudication avoidance boards, DAABs, are the latest DB offering, introduced in 2017 as FIDIC's flagship dispute mechanism and successor to its DAB. The DAAB is intended to be an all-inclusive dispute board mechanism. At its core, it's a DAB and is empowered to issue binding decisions. However, it has a new emphasis on dispute avoidance, including the power to provide informal assistance and advice on issues and disagreements, and it sits at the center of an expanded claims and dispute procedure. The DAAB represents the most comprehensive dispute board today, and it exemplifies a trend amongst the DB institutions to focus on claims management and dispute avoidance first, with adjudication as a last resort. Now moving to the key elements of the procedure, and I'll hand to Sana.
The key elements of the procedure in an arbitration are usually as follows. Firstly, referring a dispute to arbitration. Prior to referring a dispute, the referring party should ensure that it has complied with any pre-arbitral steps required by the contract, including any DB and amicable settlement provisions. For institutional arbitrations, a party refers the dispute to arbitration by issuing a notice in accordance with the contract and the rules of the applicable institution. The parties, together with the institution, will appoint the tribunal or sole arbitrator in accordance with the rules. following which the terms of reference and procedure are agreed. The arbitration process is similar to many court procedures, and the presentation of evidence will often be dictated by the background of the parties, their lawyers, and/or the tribunal. Memorials or a common law approach can be adopted if all parties agree. In our experience, where English parties or lawyers are involved, there will often be 2 rounds of pleadings, some limited disclosure, witness statements and replies, expert reports and replies, and then possibly a joint statement, followed by a final hearing. The ICC aims to issue an award in 6 months from the date of the terms of reference. However, in practice, this is often extended to suit the evidential timetable. In terms of timeframes to award, from the end of a final hearing, in large disputes, it's not uncommon for parties to wait over 6 months to a year for the publication of an award. Whilst arbitration is in theory meant to be a more efficient process than court proceedings, the reality is that large complex disputes can go on for several years before an award is issued. Robbie?
As regards dispute boards, in the last few years, the major dispute institutions have released new sets of rules that provide for a broader role for the dispute board focused on claims management and dispute avoidance. Although the powers vary widely, each of the new sets of rules share the following key elements. Firstly, all of the main institutions now call for standing dispute boards wherever possible. In practice, ad hoc dispute boards are still used extensively, for instance, in the 1999 FIDIC Yellow and Silver books, and will continue to be appropriate for smaller projects. However, the problem with ad hoc dispute boards is that they frequently do not serve the intended purpose of fast, informed assistance. The main issue, and this is something that Sana and I have both dealt with many times, is that if you wait until the dispute has arisen to set up the DB and one party does not cooperate, it can significantly delay a party being able to refer the dispute, which will then be decided by people with no prior knowledge of the project anyway. In that scenario, a party will often be better served without a DB procedure and proceeding directly to arbitration. Secondly, the rules call for regular meetings and site visits, and obviously this is something impacted by COVID-19, and we'll touch on this later. They all now include an informal advice provision, so care is needed here. Where a DB is empowered to issue binding decisions, this does not sit naturally with it also being asked effectively to mediate between the parties. For instance, if sensitive information is disclosed in confidence to the DB during informal discussions, this could lead to questions of natural justice being breached if a decision is ultimately required on the matter. The solution here is that parties seeking informal assistance should ensure they both meet with the dispute board together and never alone. Fourthly, either party may refer a dispute for a recommendation or decision. Once a referral has been made to the dispute board, it will then have a specified period of time to issue its recommendation or decision. For instance, 84 days under the FIDIC and SIARB provisions and 90 days for ICC. Although the parties and DB can agree to extend the time limit, the purpose is for it to be a short and sharp procedure. There's a lot of scope for flexibility. However, a typical procedure might entail a response within 4 weeks, replies within the following 2 weeks, and a hearing and possibly questions from the dispute board shortly afterwards. Once a decision or recommendation has been issued, the parties will have a short period of time, between 2 to 4 weeks, to notify the other party of their dissatisfaction with it, failing which they'll be deemed to have accepted it. Now, this is only really immediately important in relation to DBs who can issue decisions, in which case the failure to issue a notice of dissatisfaction on time will make the decision final, and it will become immediately and summarily enforceable in arbitration. Finally, obtaining a dispute board decision or recommendation is a condition precedent to referring dispute to arbitration, except in very limited circumstances. So, to enforcement and enforceability. Sana?
There are 2 aspects to this. Firstly, enforceability of the arbitration agreement itself. As mentioned previously, an arbitration agreement is separate to the underlying contract in which it is contained. If a main contract was terminated or found to be invalid, that would not necessarily affect the validity of the arbitration agreement. The principle of separability is recognized in most key arbitral jurisdictions and is necessary to ensure that arbitration remains a workable and effective method of international dispute resolution. The second point is the enforceability of arbitral awards. The New York Convention provides an international framework for the enforceability of awards. There are currently 164 parties, beg your pardon, to that convention. Most have ratified. the convention, and countries that have signed and ratified it agree to recognize and enforce awards made in other contracting states. Where a state has ratified the convention, awards must be enforced by the national courts, subject to certain very limited defenses. Robbie?
To dispute boards and enforceability, dispute boards are intended to be a mandatory precondition to formal proceedings, and this is broadly accepted and enforceable everywhere. A common issue, however, is if and when a dispute board can be bypassed in any circumstances. The two leading cases on this issue come down on different sides. In the English case of Peterborough City Council and Enterprise, the claimant attempted to take a dispute directly to court on the grounds that the other party's conduct made it clear that a DB decision would not be complied with and litigation would be necessary anyway. Although the judge had some sympathy with this position, it held that the litigation could not proceed until the DAB procedure had been completed, finding that it was a mandatory precondition that could not be bypassed. On the other side of this issue, the Swiss Supreme Court considered a case in which the claimant had spent 15 months trying unsuccessfully to set up the DB, the failure of which was at least partly caused by the passivity of the defendant. Although the court did confirm that completing the DAB procedure was a mandatory precondition to arbitration, it permitted the DAB to be bypassed on these facts, as it found that under the civil law principle of good faith, the claimant could not be blamed for choosing to skip the DAB procedure, and the defendant could not in good faith now insist on the DAB procedure, given its failure to participate earlier. Concerning civil law jurisdictions at least, there's now a reasonable body of arbitral awards permitting dispute boards to be bypassed where the completion of this process has been significantly delayed or prevented by tactical maneuvers, as one arbitrator put it. Whereas, as a matter of contract, the new FIDIC procedure now permits dispute boards to be bypassed when a dispute arises and the DB has not yet been set up. But to summarize the issue, the risk is that if a party were to proceed to arbitration or court before completing the dispute board procedure without a valid justification, they may have their claim dismissed for lack of jurisdiction or any resulting award treated as void. So for our purposes, it's perhaps sufficient to say that unless the contract says otherwise, dispute board procedures should be treated as enforceable. As to the enforcement of dispute boards, where parties agree to empower dispute boards to issue binding decisions, it will not always be the case that the resulting decision will actually be enforceable. This chiefly concerns not final DB decisions, which is where either party issues a valid notice of dissatisfaction. Typical issues with enforcement include, firstly, the contract wording. Because dispute boards are purely creations of contract, it's essential that any powers are very clearly defined. To the substantive issues, secondly, is whether the enforcement of a not final dispute board decision fits within the definition of an enforceable arbitral award under the New York Convention and/or any arbitration legislation in the applicable jurisdiction. And lastly, whether the enforcement complies with the principle of res judicata, which is that a matter that has already been decided cannot be decided again. Now, this is because the summary enforcement of a dispute board decision to be later followed by a final award by the arbitral tribunal on the substantive merits can be viewed as there being two decisions on the same matter. Jurisdictions where there's no substantive problem enforcing dispute board decisions include Singapore, South Africa, and Namibia, whereas in Romania and Bulgaria, the highest courts have declared that not final dispute board decisions are not enforceable, and it's expected that a similar result would be likely in the UAE and other MENA countries, although I'm not aware of any decisions on the point. Now, this topic can't really be discussed without at least a brief look at the Persero and CRW series of cases. The cases involved a project in Indonesia governed by Indonesian law, with an arbitration agreement under the ICC rules and an arbitration seat in Singapore. The contract was based on the 1999 FIDIC Red Book and so included a DAB able to issue binding decisions. And these cases involved CRW's attempt to enforce a not final DAB decision issued in its favor. The first point goes to applicable law. The dispute board procedure was subject to the governing law of the contract, Indonesian. However, the arbitration seat, and therefore, in this case, the governing law of the arbitration agreement was Singapore. Therefore, although the contract and dispute board agreement were governed by Indonesian law, the question of the enforceability of the DB decision via an arbitral award was decided as a matter of Singapore law under Singapore's arbitration legislation. The second point is as to the enforcement of the decision. CRW went through all of the Singapore courts twice over a period of 6 years before the Court of Appeal finally settled the position in Singapore that not final DB decisions can be summarily enforced. The problem with enforcement in this case all stemmed from defective contract wording with the 1999 FIDIC contracts, which has been the subject of endless debate and legal gymnastics since their release. The Singapore courts did not consider that the two substantive issues I've dealt with above prevented a dispute board decision being enforced under Singapore law, although the dissenting judge in the final Court of Appeal decision did. In any event, these cases showcase some of the issues with enforcement with dispute board decisions and highlight the importance of clear wording for any powers given to the dispute board. And now, to conclude, some lessons from COVID-19. Sana?
So, lessons from COVID-19. COVID is an unprecedented issue, as people will keep telling us, with continuing effects. Construction projects have had to find ways to restart or continue working, often with very strict limitations on the movement of people in and out of sites. This has made conducting in-person site visits and hearings extremely difficult, and DBs and arbitral tribunals are having to adapt to a new way of fulfilling their functions. Prior to COVID-19, there was a trend starting towards holding some meetings and hearings virtually. This was, however, happening by agreement of the parties, whereas now that virtual meetings and hearings are in many cases the only option, there are issues as to how this can be catered for. For arbitration, some arbitral institutions, such as the ICC, have published guidance on how their rules can be interpreted to accommodate virtual hearings, whilst others, such as the Hong Kong International Arbitration Centre and the Korean Commercial Arbitration Board, have issued guidance on how such hearings should be conducted. As regards to DBs, there is very little guidance within the DB rules themselves. We understand that many of the DB institutions are preparing guides for virtual hearings post-haste, and that the Chartered Institute of Arbitrators has recently released a guide for virtual hearings that can be applied to arbitration and DBs. For DBs, however, it is essential that the DB is empowered to hold virtual meetings and hearings. The 2017 FIDIC contracts, for instance, require in-person meetings to take place and permit virtual meetings only by agreement of the parties. The first step would be to check the contract, but we are in uncharted waters. Robbie?
In terms of how these meetings and hearings might proceed, familiarity with digital meeting platforms brought about by COVID-19 will likely make virtual meetings far more accessible and productive than certainly I would have anticipated 6 months ago. Additional technology can also supplement virtual meetings, and for instance, drone videos can allow access to projects that site visits often cannot match. As for hearings, a number of operators are offering virtual hearing facilities. The ICC, for instance, is developing a virtual hearing solution, and we expect this to be a fast-moving market. The benefits of virtual meetings include that it's easier to find available dates, it will encourage better participation, for instance, by company executives, and of course, the cost. The downsides include that it's more difficult for the parties and the DB or arbitral tribunal to build relationships and discuss or advocate issues in depth. Going forward, our feeling is that there is an appetite for a mixture of virtual and in-person meetings. Hearings will be more difficult, of course, and it's hard to see how a virtual hearing room will match in-person proceedings. However, the world of virtual meetings and hearings is going to be a fast-moving landscape, and I'm sure at least most of us here are very interested in seeing how it develops. Thank you.
That's excellent. Thank you, Sana. Thank you, Robbie. That's been very, very interesting. And I can say that because we've had a number of questions that have come in. There have been a number of questions in particular in relation to dispute boards. And I think it's worth saying that if people are interested in finding out more about dispute boards generally, then they should check out the website of the DRBF, the Dispute Resolution Board Foundation. That has a wealth of information about dispute boards, how they operate, can offer lots of tips. And indeed, the DRBF should be issuing their own guidelines for virtual hearings and virtual site meetings in the next few days. So everyone should be looking out for that. The DRBF has also carried out a lot of research about dispute boards. It was actually answer one of the questions that came in. We're being asked about whether we agree that dispute boards are proactive in preventing and avoiding disputes, or where dispute boards are aiming for a win-win solution. And I think our own anecdotal evidence from Fenwick is that yes, dispute boards are very proactive in doing that. But if you look at the research that's available on the DRBF website, they'll actually sort of show you that between 85 to 95% of recommendations and disputes that are made, recommendations and decisions that are made by dispute boards during the occurrence of a project, they lead to a final resolution or agreement of the issue in dispute, and they don't actually go to arbitration. And I think, Robbie, earlier you were talking about the costs of the dispute board process, and someone asked about whether there were any precise figures. And again, the DRBF has been carrying out some research about that, and they would say that on average the cost of a standing dispute board, that's what Robbie was talking about, the dispute board that starts at the beginning of the project, they reckon that's about 0.15% of the total project value. And as Robbie said, that might sound a lot by itself. Compared with the costs of an arbitration, it's nothing. And also arbitration can go on for 2-3 years after the project has completed. But there's been a lot of interest about your closing comments. People are interested in the concept of virtual hearings, and there's sort of some concern, and you did touch on this to some degree, about if a dispute board or an arbitral panel, they have a virtual hearing, does that affect their jurisdiction at all? So it's probably aimed at both of you. Maybe Sana first.
I think the answer to that is probably no, and I say that for 2 reasons. Firstly, the rules of arbitral institutions like the ICC normally accommodate and allow the tribunal to determine how a hearing should take place, including virtually. And in the case of the ICC's 2017 rules, video hearings are set out as particular options. The ICC has also, amongst others, produced guidance on how to incorporate video hearings into its procedure. And I think the jurisdiction issue only really arises if a party doesn't agree to a video hearing and the tribunal go ahead regardless. Which brings me on to my second point, really, which is, I think, a challenge to the award for serious irregularity, which is what I think this would fall under the Arbitration Act. The English Arbitration Act is very unlikely to succeed. Statistically, I believe that between 2015 and 2018, there was only one successful challenge on the basis of serious irregularity. So I think the answer is likely to be no, from an arbitration point.
Yeah, similarly for dispute boards. I mean, dispute boards have a lot less comprehensive institutional rules, but it's going to still all depend, as we've been saying, to the powers granted to the dispute board. But in the main institutional rules, I don't see it being a problem. I mean, looking at FIDIC's 2017 and 1999 contracts and across the board with the rules, actually, the dispute board is empowered to establish the procedure for any hearing or meeting. And while site visits are required to be held in person, there's no specific requirement for hearings to be done so. So I think provided the dispute board establishes a procedure that's fair, it doesn't breach principles of natural justice, I don't see there being a problem.
Okay, no, that's interesting. Now, of course, when talking about dispute boards, you tended to focus on the FIDIC form of contract, which is understandable. And we were asked about the extent to which JCT and the NEC contracts make similar provisions. Of course, I think the NEC contract in version 4 has introduced specific dispute board option as option 3 to their dispute resolution guidelines, and they also introduced increased tiered dispute resolution procedures. And I think also with the JCT contract, there's always there, I think parties are encouraged to consider mediation. But you also mentioned, Robbie, you touched on the Housing Grants Act adjudication in both UK and also New Zealand. Interesting question did come in. Do you think a 3-person DAB can actually act as an adjudicator under the Housing Grants Act?
Yes, yeah, I think it does. I mean, as you said, the latest NEC4 contract provides for 2 dispute boards, one that's housing grants compliant and one for contracts that are not bound by it. But they both enable the parties to choose a single or three-person dispute board. The difference with the housing grant compliant one is that the decision has to be binding and issued within 28 days and compliant with the Act in other respects. But looking at the Act itself, the Housing Grants Act does not specify that the adjudicator has to be a singular person. And actually looking at the interpretation of the Act, generally singular can include the plural and words importing the masculine gender, because adjudicator is referred to throughout the Act as adjudicator or he. The masculine gender can include the feminine. Now, I appreciate the scheme of the Act refers to the adjudicator being a natural person, but the scheme will only apply where there's a construction contract to which there's not a compliant adjudication provision. So where the parties have specifically agreed a dispute provision, there's no need to look at the scheme. And looking at the Act alone, I don't see any reason why a three-person dispute board can't comply as an adjudicator.
Okay, well that's actually quite good to know, because I think it's one of the reasons it's been thought that there isn't much take up for dispute boards in the UK is there is this adjudication, and if that's in fact the dispute board could act as an adjudicator, then therefore there's sort of compliance with the Act, then I think that may be of benefit to people, particularly on some of the bigger projects in the UK. We've got time for one, final question. Sana, you talked about the Enker case. You talked about the fact that it was being heard before the Supreme Court, in fact had been heard before the Supreme Court this week. Getting your crystal ball out, what's the Supreme Court going to decide? Who's going to win?
Well, I think that's a very difficult question. But what I can say is I think the Supreme Court is unlikely to come to a decision that undermines the validity of Enker's arbitration clause. The real question, I think, is whether the court will side with the presumption in Sul America that the governing law of the contract applies, or the Enker Court of Appeal decision where the presumption was in favor of the law of the seat, or perhaps thirdly come up with some other reasoning that allows discretion to side with either proposition. I think, however, if I was going to pin my colours to the mast, I would say that the court is more likely to side with the law of the seat. And I say this because I think, for example, if you have a case where the governing law of a contract belongs to a jurisdiction where the application of that domestic law undermines the parties' agreement to arbitrate, as can often happen actually in practice, applying the law of the seat instead might give effect to that agreement. Further, I think in international construction contracts, arbitration clauses are often included to ensure neutrality. So if you had a state entity, for example, applying its law to the arbitration agreement and basically try and have the case heard in a local court, that has the potential to undermine that neutrality. I think it's difficult to predict how the court might reason its approach and how far it might stray from the test in Sul America, but watch this space.
Okay, no, thank you. We will be inviting you back to discuss the case on a future webinar once the Supreme Court's actually rendered its decision. So thank you very much, Robbie. Thank you, Sana. That's been very interesting, very entertaining. Thank you all for listening, and thank you all for your questions. Just a quick advert for next week. We're heading across to Dubai, where our head of our Dubai office, Ahmed Ibrahim, will be discussing the arbitration law in Dubai and looking in particular at interim measures under the UAE laws and arbitration laws. So thank you all for attending. Stay safe, and hopefully you'll join us all next week. Thank you. Goodbye.